Welcome to Shaken Not Burned, a cocktail of solutions for a sustainable future. I'm Felicia Jackson.
And I am Giulia Bottaro. Each week we interview experts to talk about parts of the sustainable transition and what you and your business need to know to succeed.
Sustainability is complex and constantly evolving, and it can be hard for a business to adapt and remain competitive.
We are here to help you learn all about the changing economy and the ongoing transition.
So join us as we explore the concepts and the tools you need to plot a course for a sustainable future.
Welcome to a new episode of Shaken Not Burned. I am your host, Giulia Bottaro. There are many ways to take climate action. One of these involves going to court. An increasing number of groups worldwide are driving change through legal means in a process commonly known as climate litigation. Law has an important role to play in the sustainable transition. But how should companies deal with this growing trend? We're covering this topic today with Shaneta Sedilekova, Director in Climate and Nature Risk at Planet Law Lab. Lovely to have you with us today, Shaneta.
Thank you so much for inviting me, Julia.
Before we dive into the conversation, can you tell me about your work and how you got into this part of the law world?
Well, I first got into law and then I got into climate risk. So the legal journey really started, with law school. I decided to study law as I was finishing my high school in Slovakia. I came to Glasgow, to Scotland, did my first law degree and then 3 law degrees later. As you can imagine, law is an undertaking, but also I really enjoy studying. I really enjoy that intellectual pursuit of it. I ended up in London with a training contract with a London-based law firm, Clyde & Co. And I trained for 2 years. So as a lawyer, you have to train. And with my master's, I did my master's before I joined Clyde & Co. And I focus on environmental law heavily. And as part of environmental course, it's quite interesting to talk about it, but 90% is usually about pollution. And then 10% is about biodiversity loss, climate and water. And I got interested by those 10% more than the pollution part. And when I started training at Clyde & Co., I was very focused on finding a place in the law firm that will allow me to kind of implement that knowledge that I felt was quite unique at the time, in a sense that not many people have it, because at your bachelor degree, you're just not exposed to environmental law in that sense, and environmental risks especially, which was also a part of my studies. So I landed a position in climate and resilience team, and I was with them for almost 3 years. And throughout that time, I was doing a lot of climate risk. So it's not necessarily climate litigation. Climate litigation involves suing companies and governments for their action or inaction on climate, whereas my job was actually advising companies how to mitigate their risk of being sued. And that mitigation means you do the right thing. So essentially advising companies how to do the right thing, because when you do the right thing, nobody will sue you, right? You get sued if you are perceived that you haven't done the right thing or you are actually not doing the right thing. So I was there a couple of years and I started expanding my knowledge into nature. I felt around 2019 during COVID that this is much bigger than climate, that the issue we are facing, given that I also had studied environmental law, I knew it's not only climate. So I started expanding my knowledge into nature, which is when I set up Planet Law Lab and started working with my own clients. At the time, it was smaller companies, NGOs, governments as well. I worked with a few governments and I was helping them to expand their climate strategy into nature. And the questions were, we have a climate strategy. Do we lift and shift it to nature or do we have to adjust it? And oftentimes the answer was no, you can't really lift and shift it. But the way you have to adjust your climate strategy so that it also expands to nature, but it's specific to nature, is very specific to you as a company or specific to you as a government. And that's what I have been doing for the past 3 years as well. So I was doing Planet Law Lab and Clyde & Co. side and side for 3 years. And then obviously I focus only on my business, which is where you're meeting me now.
Amazing. Congratulations. An exciting journey. And I also feel that it's quite timely, your interest in nature, because it feels that the discourse was about climate and emissions for a few decades, and now really feels like businesses are starting to look at nature and their impacts. And, we had the biodiversity COPs and all of that. So, yeah, so going back to the concept of climate litigation, can you talk about what it is and how it can achieve climate objectives?
Yes, of course. So climate litigation, I will take that question in two steps. I'll tell you what climate litigation is, and then I'll add the strategic ones. So we have a term climate litigation, and then there's a term strategic climate litigation. So climate litigation essentially means cases, lawsuits that are filed against before judicial bodies, against governments or corporations, and they concern certain issue related to climate change. So they either raise issues with climate science or climate policy that the government adopted, or climate action by the corporates, the way they speak about it. So that would be greenwashing lawsuit. So climate litigation, when you take just climate litigation, it means lawsuits that are filed and concern some issues surrounding climate change. Now, the strategic lens is very interesting because strategic climate litigation means that these lawsuits are brought with a purpose beyond litigation. So when you think about ordinary litigation, you suffer a loss, you slip in a department store, your bag is hurt, you have to go to a hospital, so you sue the department store. Usually the lawsuit is settled because they know that you have a valid claim. And that is you as an individual seeking remedy for yourself, right? That is very individual remedy. And that is a traditional type of litigation. Now, in strategic litigation, what you do is you bring a lawsuit, not because you necessarily are seeking remedy for yourself, although that is also part of the lawsuit, but you are bringing the lawsuit to advance debate on the issue. So when we talk about strategic climate litigation, it means these claimants, NGOs or individuals, are bringing lawsuits to advance the discourse, the debate on climate change and action on climate change beyond their lawsuit. So they would be seeking, let's say, compensation, or they are seeking injunctions. But there is an ancillary part to that primary aim of litigation, which is to advance action on climate change, to raise public awareness, or to create liability risk, right? To create the risk for companies which is involved in doing the wrong thing, which means that you will pivot them strategically into doing the right thing in the transition to the net zero economy. So the phenomenon is much bigger than litigation itself.
Okay. Just so I understand, when you say that the ancillary aim is to raise awareness, does it mean that the claimants are accepting the fact that they may lose the lawsuit that they're launching? Or are they still hoping to win?
I mean, anybody who brings a lawsuit, I think, hopes to win. I think it's inherent. Strategic cases are really chosen with that in mind. Like you wouldn't bring a case if you think you are going to lose. That's not your well-spent money, because cases are pricey, right? Cases involve expenditure. So you wouldn't bring a case if you think it's going to lose. So every climate case that is brought, like the intention is actually to have a successful end, which is usually that you get what you ask for, you get your declaration or your damage is granted. However, in strategic climate litigation, it is true that even if the case loses, if it's unsuccessful in those binary legal terms of losers and winners, it still can be very impactful for climate action. So to answer your question, perhaps very legally through the back door, as we lawyers always do, right? I would say it's the success of a strategic climate case does not determine its impact, right? Even a successful climate litigation case could have massive impact because it can still raise public awareness, right? It can still create liability risk. Impacts of climate litigation currently are under review. There are several academic articles coming out that look at fall in share value after a litigation is filed, another decrease in share value after a climate lawsuit is successful. So there are case studies academically being published now, which actually show you the impact, but there is still a lot of research that needs to be done, especially empirical one. But given how nascent climate litigation as we know it is currently, for empirical studies, you actually need at least a decade of certain data And litigation is a really slow process. Some of the cases have been before the courts for 10 years now, which is why it's so hard to tell you we have impacts and these are the impacts. What we can see is these anecdotal impacts, right? Impacts that you see through shifts in the society or through media attention to climate litigation, or through the fact that people actually are talking about it. Like the fact that you invited me to talk about it means that not only lawyers, right? It's not a self-serving exercise because you're not a lawyer and you want to learn, which is a huge things for lawyers to actually be able to talk to people who are not lawyers and you care about what we do. That doesn't happen often.
Yeah, I think I think it's really important for our audience to learn about the concept of climate litigation because it's on the news a lot, and obviously I'm interested in sustainability and I try my best to learn and understand things, but I wonder for somebody who is outside of our world, what does it mean for them to read these big headlines saying the Dutch government has been taken to court or Shell has been taken to court, all of these things. So yeah, actually one of my questions was, when did this trend start and how is it growing? When did it start growing massively? Because in my head it's growing, and I feel also that the studies will say that it's growing.
Okay, so I'll address your question. So when did it start? What are the trends in terms of numbers? But I also, and I'm making a mental reminder here for myself rather than you, I also want to answer a question that came out of that question, which is, how do you understand climate litigation in the bigger context of climate action? Right?
Okay.
As a non-lawyer, like how do you conceptualize it? Is it just like lawyers having fun before courts, which is actually not what it should be? So I'll answer the two. So in terms of starting and the trends, so it started, the reports that we have access to documented back into 1970s in the US. So think about the kind of era where a lot of environmental pollution was actually causing public concerns in the US, and people, Rachel Carson, Silent Spring would come out and all the books kind of raising consciousness about environment. And that's where we have increase of environmental litigation. And that's also where climate litigation was born as a concept. Now, the growth was very, very slow. So for 30 years, it was kind of, few cases filed here and there, but nothing major. And then in 2015, the Paris Agreement was signed. So Paris Agreement on climate change is an international treaty giving us framework and vocabulary to speak about climate. And then we saw doubling of cases between 2015 and 2020. So in the 5 years between 2015 and 2020, the cases doubled when you compare them to what was filed before 1970s and 2015. So, incredible when you compare 45 years to these 5 years, doubling of cases. That shows you that Paris Agreement was that pivotal moment for law. Usually law and any legal action, including litigation, needs legal framework as a springboard. And that's what the Paris Agreement was for climate litigation. So we saw this doubling. And then, COVID hit, everything slowed down, including litigation. And we saw increase. So since 2015, we saw gradual increase, which peaked in 2022. And since 2022, what we have seen was this leveling off, which means similar number of new cases filed every year. So a lot of studies currently are looking at why. Why is this the case? Why do we have no more increase? We still don't know. Again, empirical studies are hard to conduct at this stage. There is a lot of hypotheses more. But some of them are talking about the fact that currently all the strategic cases we needed in climate litigation have been filed. And it's almost like a wait and see game. And I know that we will talk about some of the cases. So I'll give you examples of those big cases that could mean a lot for the entire climate action, not only for legal climate action. So right now, it is the same amount of cases. It is the leveling off that we see year on. And the reason genuinely could be that we have all those strategic climate cases pending before court. Some of them are in evidentiary stage. Some of them are pending judgment. We have one big case pending judgment now. So it is a very interesting trend to observe. Like, why is there the leveling off? Once these big cases are decided, we do expect a massive increase. Because once you have, and I'll stop here because we'll talk about it later, but once you have a court approved formula for some of the big questions like damages that big corporations should pay for their contribution to climate change, then obviously there'll be more incentive to sue these companies. So that's one of the reasons. Now, I wanted to address the kind of ancillary question, which was the question of how do you understand as a person who is an ordinary citizen without legal education, and law is such a language of its own as any profession has become over the past 30 or so years. So how do you understand it in the context of climate action? Climate litigation is just one aspect of climate action, right? You can have climate protests. You can have as a lawyer, you can do climate contracting, so you can incorporate climate considerations into contracts. You would have corporate voluntary action, which actually doesn't depend on litigation. So there is so much happening, and climate litigation is just one lever of change. Because if we understand that what we are doing right now, we are in this transition. We all talk about transition. Some people call it net zero transition. Some people call it nature positive transition, energy transition, economy transition, just transition, but it's a transition. And we gave ourselves deadline in the climate space. The official deadline is 2050, zero emissions by 2050. But that is the deadline we gave ourselves to have a goal, to have an aspiration. We don't know how it will be met. There is a lot of question marks for it. But in that transition, what we are really transitioning is our ways of living and doing business with one another. So it's much bigger than law. And law is just one lever of change that needs to change, because law needs to transition very much like every business and every industry and every government needs to transition. So law is transitioning through different means, and one of them is climate litigation. One of them is, the actual, immediate result of climate litigation, which could be the court judgments giving us more clarity, court judgments that can actually force governments to adopt ambitious policies and then impact corporations. Or it could be those more non-tangible impact that we talk about. If a case is unsuccessful, then it would lay ground for the next case, because judges usually tell you what was needed for the case to be successful. So the next group of litigants will know a bit more. They will know what we need to do differently next time. Or it could also just raise public awareness. And you mentioned the point that a lot of media covers climate litigation these days, which is how public is becoming aware of it. And my final point being, climate litigation, or any litigation really, can be very inclusive, because unlike a lot of other climate action, maybe climate protests excluding, but a lot of climate action on a corporate or government level is very much divorced from the individual. You as individual feel, what can I do? Well, I can vote, but that's an indirect way of impacting climate action, right? If I vote for the politicians which are in favor of climate action and know what to do, then I'm still engaged, but it's that kind of citizen way of engagement. So if you feel how can I do it myself in everyday life? How can I engage? Litigation, I think people find litigation attractive because you as an individual citizen can become a claimant. You can join class of claimants, and you can really feel that you are making a difference in climate action in this way, which is why I think it's receiving so much media coverage, perhaps much more than climate contracting or other ways of legal climate action, because it does involve ordinary people, and it creates that union between the lawyers and the people trying to push the economy in the direction that it needs to go.
Super interesting. I love that everyone can play their own role. So the lawyers bring their knowledge and the citizens bring, I don't know, their anger, their upset,
and the entitlement, because you have to, as an individual, you have to be wrong to be able to bring a case, right? If I would never be able to sue you unless you wronged me, right? There needs to be, we call it in law, there is an obscure term, cause of action. So I need to have a cause of action. You need to wrong me for me to bring a case. And lawyers, we can't do anything unless we have a client. And me as I do advisory work, so I need a client to advise to. Lawyers who pursue climate litigation needs claimants. They actually need the citizens who have been wronged to be able to act on their behalf, right? So it is that kind of symbiotic relationship where we can't exist without one another.
It's also very empowering, and I think it can assuage perhaps those feelings of climate anxiety, the doom and gloom that a lot of people feel. A lot of people think the world is burning, there's nothing we can do, we're being crushed by the very powerful people. But actually, this shows that it's not entirely true. There are ways where we can show that we've been wronged and seek compensation or change.
Yes, yeah, I do agree with you. It can be a healthy and active way of filtering anxiety if you feel any. It can also be a way to find your community, people that could hold you when you fall, when you have those low moments. For me, perhaps the litigation, when you conceptualize it as in a normal life, you want to resolve conflict by talking, right? You and I need to talk and resolve our issues. Now, if we don't understand each other, we start shouting, right? Because I feel like you don't hear me, so I'll shout at you. And then if a communication between two of us breaks, we need an independent third party. We need a court, right? It could be a judge or it could be an arbitrator, different forms of litigation. But when communication between two parties break because they can't find a common ground, they can't, it could be emotional, there could be so many things involved, then you bring in the third party. And what we see now, another way to conceptualize climate litigation is the citizens screaming at the governments, telling them that you are not hearing our calls. Like we struggle. Economy is a wholly owned subsidiary of nature. If we destroy the nature, the basis on which economy functions, and obviously nature also regulates the climate system, so you have the relationship there. If we destroy that basis on which our entire civilization and economy and everything we have developed over the past hundreds, thousands of years as a civilization on Earth, if we destroy the very basis of it, we destroy our society. So it's almost as if the contractual relationship, the social contract between the government and citizen is no longer something that citizens feel they can negotiate peacefully in a through elections, which is a way of expressing your preference for government or for a certain policy direction. So in that way, climate litigation is that moment where citizens come to scream, right, at the government. And most climate cases to date have been filed against governments. So because they feel that they're not being heard, right? That's one thing. And if the government is smart enough to notice, then they'll be like, well, we have quite a few unhappy citizens. Climate protests are another way, right? It's another way of citizens screaming at the governments for not doing what the citizens need them to do. And then also climate cases against corporations. It's the citizens, trying to redirect financial flows because we need so much money to put into climate action. And currently, very little, I think only 1% of global finance is going into climate action. So you need the money. And if the corporations are not voluntarily pivoting to green energy, not voluntarily pivoting into business models that are not harmful to nature and climate, then the citizens start screaming, and they scream through litigation. They scream through protests before headquarters of these law firms. So again, you can see litigation as this response to failing democracy, failing governments, failing corporate action, where citizens really get to the point of, okay, protests are one thing, but then litigation is that systemic thing, because you break with the system, you break with the legal rules that the government and policymakers and parliamentaries have given you to express your discontent.
We love systemic change here at Shake and Not Burn. This is one of our keywords. This seems like a nice segue to talk about the high profile cases that you mentioned earlier and that we should be awaiting results of very soon, hopefully.
Yeah, like this is such an exciting time to talk about them. So the one I really want to spend more time talking to you about, it's called Luya against RWE.
Mm-hmm.
And it is a fascinating case. It is a case which was brought by a Peruvian farmer. So we have this actual, again, like individual claimant who resides in Peru. And he resides in the part of Peru in a village which is threatened by melting glaciers. The idea being, if the glaciers melt, they will overfill this lake, which is formed in the mountains, and then the lake will spill over and flood his village, causing damage. Okay, so this is the factual scenario happening in Peru. Now, we know, and I'm sure that you have spoken about the phenomenon of global north and global south at your podcast, where we know that most climate harming substances, greenhouse gases, have been emitting throughout industrial revolution and then industrial progress in the global north. But a lot of the impacts are felt in global south. So this Peruvian farmer, instead of suing Peruvian government or pursuing the action in Peru, which is a country of the global south, which contributed much less to the current problem, has come and brought his case in Germany against one of the biggest German utility companies, RWE. And what he's saying is that this utility company historically emitted greenhouse gases. Those greenhouse gases enter the atmosphere, accumulating there with greenhouse gases of other companies, and cause the warming of the glaciers in his country, in the mountains, that are now threatening to flood his village. So from legal perspective, from a perspective of a normal human, this makes sense, right? Like that's how climate operates. In climate, no single company's emissions cause the warming. It is the accumulation of emissions that causes the damage and the potential and actual damaging impacts. So, it makes sense. Legally speaking, it's a really difficult argument to make because law is always territorial. So German law applies in Germany. Peruvian law applies in Peru. English law applies in England and Wales. We have all these, we as people, we live on land. So we establish our institutions on the territory which we occupy as a nation or a country. So all of a sudden, courts have to grapple with this big question of like, how do we do this? How do we consider damages that are to happen in Peru as a fault of a company that is in Germany? And the way that the case, and this is a case that has been in courts since 2015, so like 10 years currently. This is what I mentioned at the beginning. Cases move slowly, especially because they really bring these challenging questions to lawyers. We as lawyers don't know how to grapple with it, and oftentimes we need science to connect. So what do you need to prove as a lawyer? So as a lawyer who is advising on this case, you would be thinking about what is the causation. So the question is, how can I say that the emissions of this company in Germany have caused the damage in Peru? That's a legal question of causation. We usually, as lawyers, look at science. We need scientific evidence to do anything, right? We can't just create the world that we want to live in or wish we didn't live in. We really need to rely on science. And science that they rely on in this case, the claimant relies on in this case, is called attribution science. So attribution science is this mode of science where you attribute greenhouse gases to a particular company. So from historic emissions, you can actually attribute a particular volume of greenhouse gases to the company. And then you can also attribute how much those greenhouse gases do in particular. So you separate them as if for an atmosphere. It's a very interesting intellectual, undertaking that actually has no practical possibility of happening. But you separate those greenhouse gases and then you say, okay, so these greenhouse gases contributed this much to the event happening and the damages being caused by that event in Peru. It's fascinating, much harder than I think I will ever be able to understand. And this is the science they're relying on in this case. Hearings, signed evidentiary hearings. So hearings that included this farmer, Luya, but also scientists, took place earlier this year. An exciting point here, which is why I'm so happy to talk about the case, is that we expect the judgment in this case. It was expected in April, but the judgment was postponed. And now we expect it on the 28th of May this year.
Oh, okay.
And the big thing about this judgment is that what we expect to hear is, it could be successful for the claimant or unsuccessful. You have never a guarantee in any litigation. But it is the case, it is the first case where an individual is claiming damages, essentially telling a company, you need to pay this money because my village is going to get flooded. And that money is going to be used for flood prevention, to prevent the damage, or if the damage happens before the money can reach the village, then remedying the harm. Prevention is always better than remedy because the harm means personal harm. So harm to people, but also property, nature harm. So it's always better to prevent it. So the idea here is that when the court rules, we will, in a case of successful judgment, we expect to be given a formula, a court-approved mathematical formula, how to attribute emissions from atmosphere to a company, and then from the atmosphere to the actual climate-related extreme weather event, such as flooding. And once you have this formula, you can imagine activist NGOs who are the most common claimants in most cases, so oftentimes it's NGO driven, would adopt this formula and send hundreds of pre-action letters, who are these polite letters where you tell a company you intend to sue them. Essentially, you're just giving them a notice. So you can imagine how these NGOs will send pre-action letters to a lot of companies saying, look, we now know that our RWE is responsible for this much and has to pay this much. Your historic emissions on the basis of this formula are this much, and therefore you have to pay this much. So you either pay now or we will sue you. And because of the success in Luya, we are likely to sue you successfully. So you can see how that could be a massive springboard for a lot of cases. And again, climate litigation is not self-serving. Nobody wants to litigate. It takes ages, it's expensive, exhausting. You need so much commitment from the lawyers, from the claimant as well. Waiting for 10 years, having that patience, that is viable, right? Like nobody wants to sue. What you want to see is finance going into climate action. And that's why we have this litigation, right? Because the companies are not directing the finance into climate action. So you have to scream, right? You have to express your discontent a different way. So that's in a case that case is successful, there will be this formula and we can see it as a springboard for other cases. If the case is unsuccessful, you could also expect courts giving certain indication of what it will need in future for a similar case to be successful. So what do we lack? Do we lack science? In which case you would see universities putting a lot of funding into that science to develop so that it can support litigation. They might say we just need policy. We need governments to publish certain numbers or certain targets. So oftentimes even unsuccessful case actually gives you a lot of direction of what you need to do in future. And perhaps, if you follow that direction, a new case will not be necessary, because if the governments or companies do what the court suggests that they need to do, then there is no reason to sue them. Litigation is always a response to a failure, perceived or actual failure to take proper action on climate change. Mm-hmm. So that's a big case, and it's so fitting that we are talking about it at the end of April, given that the judgment is expected at the end of by the.
Yeah, it's possible that this episode will come out after the judgment, so our listeners can go and have a look. We will put the links in the show notes. I have a question about this. So I will first ask you the first question, and then I have a follow-up question coming off immediately. In what court is this case being discussed?
So this is a national court in Germany. It's not an international case, if that's what you are alluding to. It's a national court in Germany, which is ruling under German law as well.
Okay. Because my question then was, this formula, say the case is successful, so this formula will be court approved in the German court. Will NGOs that are not German be able to send this formula to those companies that you said, sort of saying you need to apply this formula and compensate or we sue? But would they be able to sue in other countries, in other courts, with this formula that was effectively approved by Germany?
So it's an excellent question. And technically, legally correct answer is no, right? Because German judgment only covers German territory. But what's happening in climate litigation is that judgment in one national court oftentimes inspires action in another. First of all, because lawyers are quite smart and they can see the differences between the systems. There are some, obviously legal systems are not the same, but they are translatable. So they can actually transition or translate, or any other word that you would want to use for the exercise, the logic, the legal arguments under German law, and transpose them into English law, for example, or into French law, which oftentimes we see one case, and the Netherlands has been a jurisdiction of a lot of inspiration for other climate cases, with a lot of successful and unsuccessful, but very indicative climate cases being decided in the Netherlands. And then we would see similar arguments all of a sudden made in English law, or even in Australia. So the communication is happening, the inspiration is happening. What it just means is that court judgment would have immediate impact in Germany for corporations that are incorporated in Germany. And then the impact in England or impact in France would take a bit longer, but that would be a natural trajectory that NGOs anything about them. They have restricted funding. They have to prove to their funders that they have impact. They are using their philanthropic funding in a smart way. So it would be a very natural thing to say, look, there is this successful case in Germany. And yes, it's a German law, but English law is similar here. This is where it's dissimilar. This is where it's different. This is where we might need to argue a bit more, which is why the corporation might say, no, we are not paying under the pre-action notice, the letter telling them they will be sued. And then there might be another case in these jurisdictions. But it's a springboard. It's always, the first incentive and almost the motivation to pursue this sort of action further until you actually see a voluntary flow of money that needs to go into climate action actually going into climate action. Because again, remember, nobody really wants to sue. There is no self-service there. Like, it's such an undertaking, especially for an NGO, to get funds, to find the right claimant, to actually find the right lawyers and commit to a case for 10 years, right? Like, it's a lot. So at the end of the day, what you want is the corporations and the governments to do the right thing, to actually pursue climate action ambitiously, realistically, and to the end to help the citizens with the transition, because we all are going through it together. So yeah, we will see. It will take longer for that case to have impact outside of Germany, but it is not impossible. It is something that we commonly see in climate litigation.
Okay, interesting. It sounds revolutionary. Moving to the corporate world, there's been a new trend emerging, which is called greenwashing. Greenwashing is basically flaunting climate credentials that you're really, they're not really based on evidence. You're not, you're basically lying about what you're doing. And greenwashing is when a company is genuinely taking climate action, nature action, but they're worried about criticism or perhaps climate litigation, and they're not really talking about it. So would you say that the rise of these cases has contributed to the rise in greenwashing?
It's an interesting question. So we have seen greenwashing litigation on a steep increase over the past 5 years or so, like really, really steep increase. I often like to say that greenwashing is not about what you do as a company. It is about what you say about what you do. So when you decide to take some action on climate, reduce your emissions, replace your fuel, innovate your fleet, whatever it is, those are your internal actions. And when you get sued for greenwashing, is not for doing them or doing them too slowly or too fast or doing them in your way. What you get sued is for how you talk about them to your customers and then to your shareholders, right? So it's the expression of your action that actually generates the risk, that increases the risk of greenwashing lawsuit. So when you understand greenwashing in that way, it's about what you say. It's not about what you do. Greenwashing signposts and successful greenwashing cases, we have had a lot of them. It signposts a lack of understanding on the part of the corporation, either about how to talk about what you do or about actually what you are doing. You don't know what you are doing, and you are talking about it as if you knew. That's a problem, right? Or you are still developing your own understanding, which is absolutely okay. We are all figuring this out as we go along. But the way you are talking about it is as if you were absolutely like on track and you were going to meet all your goals and everything was okay. And that's problematic. It's problematic from the perspective of the consumer, because consumer will then start supporting you, right? Because they'll believe that you have done your research and you know how to become a net zero airline, right? And airlines have been targeted heavily, especially because the science didn't support their claims. The science didn't support scalability of sustainable aviation fuel. It didn't support the idea that in 2050, we can have as many flights as today, but flying on a fuel that is not polluting. There was no scientific evidence linking the two, which is why a lot of airlines were being sued for greenwashing. Now, greenwashing clearly links to this, right? Because greenwashing created this liability risk, so a risk of being sued when you express your climate commitments, and therefore now we don't talk about them, right? That's the idea of greenwashing. Now, there is definitely this link, but I do not think it's detrimental, because what you are doing as a corporation when you stop talking about your climate action or your climate goals or climate policies, you are just buying yourself time to figure them out. And then you will talk about them with confidence and with a way to actually back them up scientifically. So I almost feel that greenwashing is the natural stage which companies can use to their which companies could use to their advantage, in a sense, as an opportunity to actually generate that internal knowledge, know-how, and have a trajectory for transition. Because we know that at some stage in the next couple of years, transition planning, so actually having to have a corporate plan about how you're going to transition to a net zero economy, will be compulsory. You will have to have a plan. So this period of greenwashing is almost like telling you, look at it now, hire the right people, get the right expertise on your board, start talking to your employees, start thinking about how to do this, so that in a year or two, once you start marketing it again to your customers, to your shareholders, you will be able to back everything up. You will not be making these, nebulous claims that have no scientific basis. So yes, to answer your question or summarize my answer, greenwashing litigation has led to greenwashing currently, but I do not think it's necessarily detrimental. It's buying a company time to understand how their business relates to the science and what they need to do to then talk about their climate action in a way that doesn't litigate or doesn't generate the liability risk of greenwashing.
So as you said at the beginning, if you are doing the right thing, you shouldn't be worried about being taken to court.
It's always about if you do the right thing, nobody's going to sue you.
Thank you so much, Anita, for this great episode. It's been incredibly fascinating. I've learned a lot, and I'm sure our audience has too.
Thank you so much for having me.
And to our listeners, thanks again for tuning in. Follow us on all social media and subscribe to our newsletter too. See you next week.